preliminary caveats and all can happen.
Sure. I think we can do that.
All right. So a very warm good evening to everyone. I hope everyone here is safe and healthy. On behalf of Legacies, I would like to welcome all of you to the webinar series on Decoding the Labor Code, Part 3, which is the Occupational Safety, Health and Working Conditions Code. Now, for those of you who are joining us for the first time, please note that we have divided the Labor Code into a 4-part series, and the Social Code, Social Security Code and Wage Code were covered in our previous 2 sessions by our expert speakers. Before we start the session, there are some points which we need to take care of. I'm going to quickly share my screen. Okay. All right, there it is. So we have a few housekeeping rules. Everyone is to remain on mute except for our speakers. We strongly advise you to not open any links in the chat box. We will spend the last 20 minutes on the Q&A session with our panelists, and all the questions are to be posted in the Q&A chat box. This webinar is being recorded and will be casted on the Legacies YouTube channel, and claim any copyright to the images of the labor monument and commemorative images which have been used so far. We also have a few caveats. This webinar is only for general awareness and provide information, and does not construe to be an analysis or discussion as the legal opinion on any matter. Based on the particular facts and circumstances, the legal opinion will vary. The OHS Code 2020 has been passed by the Parliament, but related rules are still in the draft form. The time for suggestions and objections to the draft rules is not yet over. Based on the final rules, some of the aspects discussed during the webinar may vary. The new labor codes with the applicable central rules are expected to be effective from April 1st, 2021. The views expressed by the panel speakers on their individual and personal views are their individual and personal views and are not necessarily the views or expressions of the organizations represented by the speakers. Before we move ahead, I would like to quickly introduce our expert panelists. Our first speaker is Mr. Rajesh Bagga, who is the founder of Uhina Law Advocates and Consultants. He has been Group General Counsel with Unilever, Tata Motors, and Reliance, and with vast experience in various sectors of the industry, both in India and abroad. He has also been closely involved with the development of regulations with governments. Our next speaker is retired Joint Labour Commissioner, Mr. Dinkar Pagar. He has experience of over 35 years in the field of resources, specializing in industrial relationship movement of Maharashtra in various capacities, such as the Joint Labour Commissioner of Mumbai, Educational Labour Commissioner in Pune and Mumbai both, and Deputy Commissioner Labour at Mumbai and Nasik. He has also been the chairman of various labor boards and security guard boards in the state of Maharashtra. Our third speaker is Mr. Suhas Tuljaparkar, who is the managing partner of Legacies Partners and the founder director of Legacies Services. He has over 37 years of experience and acts as an independent advisor to various companies, governments, trade associations, professionals, celebrities, non-profit entities, and startups. His main area of expertise is governance, risk, assurance, compliance, ethics, with a fusion of information and technology. Welcome, a very warm welcome to all our speakers. Thank you for being present here with us, for sharing your insights on this very intriguing topic. Without further ado, I now hand over the platform to you, sirs.
Hi, good evening, everybody. A warm welcome to this webinar. This is the third in the series. I missed one, but I think there was a phenomenal response to all up to now. this is one topic which is kind of making sure that we stay on our toes uh, at the end of 2020. You see, very clearly, I think we have, as usual, I think Mr. Pagar and Mr. Bagga with tremendous amount of experience in this space, with a knowledge which is unparalleled. We're going to look at the safety and health at workplace through this code and analysis of the provisions of the code. We're just trying to kind of see as to where are we today as a country and where probably look at it as a missed opportunity. I personally do that, but predominantly I'm going to kind of seek views from everybody, and especially request you to ask as many questions as you want to. Put them up in the Q&A box, not the chat box, just to kind of set the framework right. You see, uh, we've had this national policy of safety, health, and environment at workplace. Very clearly, I think there was a word added there, environment at workplace, very clearly. And it was 2009, it recognized that, you know, it is a fundamental human right to have a safe and healthy working environment. Now that's slightly different from what the Constitution guarantees us. Constitution guarantees fundamental rights, which is in relation to few of the areas such as you know right of equality. Now equal remuneration and equal pay enactment and the legislations followed the fundamental right to trade, right to practice any profession, right to be employed, right to begin fully employed, right to life, live, and livelihood were all clubbed together as fundamental rights. However, when it comes to the safe working place, you may trace back some of the elements back to the fundamental rights, but predominantly the this legislation focuses around the directive principles and directive principles of state policies, which actually say that the laws need to be made by the government which will enable both men and women to have a right to livelihood. It also says that in cases of unemployment, old age, sickness, disablement, and other cases, we need to have a public assistance provided through the government mechanism. we there's also directive principle under Article 42, which talks about just and human conditions of work, the living wage and extending conditions of the work, enabling decent standard life, also arising out of Article 43. So at one level, there is this framework that's coming from the Constitution. At another level, there is ILO. And ILO, when you talk about occupational safety and health, I think there are some conventions where we have been party to it, like the Benzene Convention or the Major Industrial Accident Convention of 1993. But the basic fundamental convention, which is actually OSH Convention number 155, which deals with occupational safety and health, India has not ratified and India is not a party. So while framing this act, is there anything else that we could have done in terms of uh, the framework and getting it linked to the fundamental rights itself? Is the question, and I'm going to request Mr. Bagga and Pagar for their views around it. Mr. Bagga?
I think, Suhas, as we have seen over the last about a decade, that the right to life and liberty has been expanded by various pronouncements of the court. And I think safety and health of not only workers but also citizens in general have been taken into account in various judgments. So while these were legislations which were very old, they did provide for a safety network for workers. But yes, I think by the coming in of this legislation, the there is no derogation of that right at all. In fact, the legislation squarely strengthens the duties of the employer and the duties of the employee to behave and to put in place a mechanism which is safe, healthy for everyone, not only themselves but also the people around them.
Fair point, sir. And the duties as it appears today in the code appears to be somewhat similar to the directive principles. You can't probably legally enforce them, but they're still there in the statute book. But we'll come to that. I mean,
Yes.
very interestingly, I think when you can't really enforce directive principles because there are duties of
Can
security.
enforce this legislation.
Yeah, you can. You can. I mean, I take that point. But Pagar Saab, coming to you
Yeah.
on the ILO, I think was it not imperative that we kind of adopt all the conventions, because now that the kind of chairmanship or secretariat is India's, so to speak, this year, from at least for next 2 to 3 years. So ILO
No.
conventions, why is it that the government doesn't ratify?
So, good afternoon to everybody. One thing I would like to emphasize over here, that no country in the world has ratified all the conventions of the ILO. Even USA and Europe also have not ratified all the conventions. That way, India, despite having their own industry since the last 200 years, and we are just about a 50 to 60 years back only, we are still in the infancy stage. I will use the word infancy stage to ratify all the conventions of the ILO. But maximum ILO conventions have been ratified by India, by which substantial rights, human rights have been provided to the working class and the non-working class of the peoples of the India. The primary goal of ILO is to promote opportunity to all to obtain a decent and a productive environment. This is a primary goal, and through which freedom, equality, security, and human dignity have to be achieved. And to achieve this equity, security, human dignity, and productive working conditions, decent conditions, this legislation plays a very important role, because once you have the law, it can be enforceable by authority. Because if we see it is that way, that if it is just a conventions are not been followed strictly by the people, but when law is there on the paper and when the punishments are been there, then the law gets enforced in India to
Fair
some
point.
extent.
Yeah, yeah. No,
Yes.
no, fair point, sir. Because there many times the critics
Yes.
come back to say that we are not party to the global convention, because global conventions, and just to kind of
Yes.
in the context of this code, if you were to look at the dangerous kind of machinery,
Yes.
the ILO standards which are there right from design onwards to supply, some elements have now come into this code, but they're far more evolved and better placed. But having said that, I'm going to move towards looking at, what are the kind of, taking a broad overview of this enactment and looking at what are some of the elements which we believe are the good, the bad, and of course there's nothing ugly. Some people may view it that way, but I think, sir, there are various things that have come up which are kind of you know which are new, but at the same time they are very important, and they're probably movements in the right direction. Just to kind of talk about what Mr. Bagaji explained a bit, was the duty of employees today. And together with that, I think when we talked about dangerous machinery, you see, we're talking about some kind of a product liability regime where we are saying that the dangerous machines, the dangerous equipments, and the hazardous substances that are being used need to be right from design stage onwards. And when it comes to construction, with respect to building constructions, ought to kind of go through broadly product liability regime, that it needs to be designed for the purpose for which it ought to be deployed. And the duties of the employees embodied in section 11. Uh, do you see this as a game changer? Because this is for the first time, I think the onus is on not merely an employer, but there are third parties such as supplier of equipment, but more importantly, employees, and the duties of employees have now been specified. Do you see this as a game changer, an extremely important element, sir? What's your comment? Pagar sir.
Basically from the health and safety point of view, cooperation of the employees is always very much needed. They cannot be escaped from the liabilities because whatever the possible precautions have been taken by the employer to deal with the health and the safety measures, then the monitoring of that safety and health is very important. And during considering the monitoring of the safety and health, involvement, participation, active participation of employees very much needed. Despite whatever the technologically improvements have been made out, there is always some time the possibility of the human errors
Mm-hmm.
which occur, which results into the accidents,
Okay.
and uh, that part employee has to play now, because vicarious responsibility, when we call it, not is only with the employer, but it also lies with the employees. So the responsibility of keeping the workplace, workstation as a health, safety and health way is also the responsibility being casted on the employees.
Sure, sir. Thank you. I'm going to come back to Bagga Saab. I think is this an element which kind of surprises everybody?
I think it's a very progressive move because we have seen in the past, and I have worked in diverse organizations of manufacturing various goods, which are some of them hazardous, some of them risky. Now, it was always a challenge to imbibe a safety culture in India. I think Indians, by and large, are big believers, and we have lots of gods. So, we believe that God will always help us and save us. Something is going to happen to someone else. But let me tell you, safety in a manufacturing organization is of prime concern. And I'll give you a small example of we had 1,000-acre plants, nearly like cities with traffic lights and everything. Now, the workers were supposed to not to drive in the plant area without a helmet. This is much before the helmet rule came in India. Because we had trucks moving, we had a whole lot of heavy machinery moving on the roads, and also there had been a few accidents where workers were found to be exceeding the speed limit and getting into an accident kind of a situation. Now it is for their own good. Now, but there was huge resistance that why helmets, because outside the plant we don't have to wear helmets. So we said, no, you please wear a helmet. As a worker of so and so, we want to set the trend across the world that helmets must be worn while driving a two-wheeler and seat belts must be on while being in an automobile. Now, here is an act which actually says that it's not only the responsibility of the employer, but also the employee to not only comply and to help build a safety environment, but also to report if there is a safety lapse on either part. Now, I think it's very healthy because the worker comes to the factory to work and to earn wages, not to get injured. And we spend so much of time and money in training workers and even visitors on safety. Now, all that goes down the drain with a single act of negligence.
No, fair point. I think, and it's also very interesting that whenever we've done some analysis of any of the accidents that have taken place in Indian context, I think the human negligence is an element, and as Pagar Sahab said, it kind of gets attributed to vicarious and contributory element to the accident, and it's a contributory factor for negligence there. But sir, now look at the rules, and I'm going to refer to the rules as the rules because they're still in the draft form. The period for suggestion and objection is still open out there, but still these rules are indicator of what is going to come up. So if you look at the form 8 there under the rules, you will find there is a column with respect to damage or loss caused by the employer by neglect or default of the employee. Sir, now you club this together with section 21, duties of the employees. If any of the employee is considered to be in dereliction of his duty towards safety, would this actually lead to an employer claiming loss or damage? Is that the is my reading right that both of these will be clubbed together? And in the earlier context, there was although there was a general provision, but there was nothing specific with respect to employer claiming loss or damage.
Yeah, that's actually stretching it a bit too far, but I think no employer wants to really charge the employee on the damage or the loss that is caused. But clearly, I think if it is a willful and malicious act, naturally, I think some action will be taken. But I feel the very fact that there is a recognition that loss could be caused by an employee by itself, I think will bring in better focus and more seriousness to the implementation of the safety regime in plants. As I'll give you a small example. A worker is charged with the duty that here is a boiler. Please take readings of the pressure every 2 hours or 1 hour. And the person goes to sleep. And then when he gets up, he files certain fictitious values. Now, if there was a pressure buildup in the boiler could have actually burst. Now, I think this is criminal negligence.
Correct.
And cannot be ignored at all, because he is not only putting himself at risk, but also putting a whole lot of his colleagues and managers and people living in the vicinity at risk. So I think a view will have to be taken depending on the circumstances.
Sure, sir. I think, and incidentally, I think where I'm kind of looking at from the Bhopal gas tragedy onwards, you see, when you talk about the liability of the supplier, and I think we've had this issue in the nuclear liabilities. You see, for the first time, we see a statement, or at least together with the duties of the employees, there is this duties of the designer, this duties of architect while building and construction. There are these duties of supplier of the equipment and dangerous machinery, which is to say that their duty has been expressed here. You see, I mean, all of us know this post Bhopal gas tragedy. We've had this issue about the liabilities becoming unlimited, even the third parties, and that's how third party liability insurance came in. Here, in this context, therefore, there is nothing in the act prescribed for a direct liability except the duties have been cast on the designer, design, supply, operate, uh, build, construct. So the architect, the designer, supplier, there is a duty cast, but there is no nexus anywhere else. I mean, if let's say supplier were to be a faulty supplier, and he is in breach of the provisions of these duties specified under this code, what happens? It's left unanswered, and the only liability is fastened onto the employer. Is that
I
correct?
think there will be penalties if the duty is provided and there is a clear breach which is proved. I think there will be penalties which could be enforced on him. There is a general penalty anyway. And negligence is actionable even outside the court.
Correct, correct.
And fact, if it is injurious to someone. So I think the very fact that the duty is provided, the person culpable cannot escape liability.
Fair point.
Or under the general law of the land.
Okay, going beyond the statute, going beyond. Uh, this come to this provision relating to women permitted to work from 7 p.m. to 6 p.m. And I'm going to move to Mr. Pagar and Pagar Sab, in terms of, there have been in past as well various attempts being made to make sure that there is a gender parity, there is gender equality and inclusiveness, because I think the large part of Indian economy, if the women workforce comes into the mainstream, we know, I think there's going to be a tremendous boost to the India GDP. This
Yes.
women being permitted to work from 7 p.m. to 6 p.m., does this actually kind of give that confidence today, these provisions under the code, that yes, we will see drastic change? Pagar sir?
This employment of women in the night shifts is a very much encouraging and emancipating the women workforce. Because since practically since 2012, and after the sexual harassment were at workplaces, the act has come into existence. Since then, this move has been started that why women should be discriminated from the working in the nights. Basically, their safety issue was much concerned, and as well as their family concern was also much concerned. Therefore, certain time was being passed how to develop a scheme and a system which will make women to work in the night shifts also. So it has come into the practice since 2013 or 14 also itself that women have started working in the factories in the night shift, provided certain terms are there. What are the terms are there? Terms is that their consent is must, number one. Number two, their transport facility should be provided to them from to the house, from house to the house. Then all the toilet facilities, washroom facilities, drinking water facilities at the at very close to the workplace. It should not be away from the workplace. It should be close to the workplace. Then safe, secure workplace also has to be provided, because it was a danger for them to have the safe and secure workplace. In number of cases, in earlier, wrong things have happened in respect to the women workers. To overcome these things, this proviso has been made that the workplace should be safe and secure for them. And in addition to this, sexual harassment at the workplace, that policy has to be there, which makes a confidence amongst the women workers that, okay, substantial care has been taken in respect of their security, in respect of their safety, in respect of their health, has been taken. And this is added to the workforce of the country, which makes that GDP growth will boost up, will grow up with the participation of the women. Because what used to happen in earlier stages, that whosoever women were, less number of women were coming to work outside their houses. Maximally, they were working in the homes. They were the home workers. Their contribution was not counted in the total GDP of the country. Therefore, when they have come out to work in the out of the house to work in the either industrial premises, facility centers, BPOs, IPs, all the things were manufacturing sectors, it has come. So their contribution has started counting it, and the counting of the contribution to the nation's building, which has resulted into the growth for the GDP. So he is one of the contributor to the growth of the GDP. So the women worker, allowing the women working in the night, has increased their confidence in them as well as to the GDP of the country also.
Thank you very much. Bagasab, your view on, is this a game changer now?
Yes, I think I'll just recount that, I was in an automobile company, and we found that, women engineers were coming through from IITs and everywhere. And there was a huge debate whether we should be employing women engineers because they would then be required to work on the shop floor. And this was a company with 99% male. Automobile companies were traditionally male dominated bastions. And we inducted women engineers and supervisors, and they performed phenomenally well. But they could bring a culture in on the shop floor which was very empathy oriented, very helpful, and a lot of compassion on the shop floor, which led to massive productivity increases. And I think it is a fallacy to distinguish women and men on the basis of opportunity. I think women embrace opportunity with far greater responsibility than men, because men tend to feel a little comfortable in male dominated industries, whereas women strive hard to beat them, and they do.
No, no, definitely, sir. I think it's a great. I recall in one of the automobile manufacturer in Pune, except for the receptionist, and this was way back in 1984, 85. Except for the front desk person, there was no woman employee in the factory premises. And when I went sometime back, at least about 2 years ago, to the same factory, you could actually see the complete change there. And I
Yeah.
think this would definitely be a game changer from 7 p.m. to 6 a.m. Women permitted to work, statutory protection, safe working places. Uh, sure.
And I think the code clearly provides basic safety measures and safeguards them from any peril that was mentioned by Mr. Pagar. And I think employers actually go far ahead because you don't want to imperil anyone's safety and well-being.
Fair point, sir. There's game changer. There's another game changer, and I want to stick with you for a while on this topic. Is this appointment letter to everyone? You see, sir, now the rules have come up. In the rules, they have kind of said what is the basic minimum requirement that needs to go there in the appointment letter, and this also appears to be a game changer. What's your views?
I think, as they say in cricket, you don't set the field for the bad players, bad shots. But here, a field is actually being set for the bad shot. It is the people, a few people in the industry who have been engaging, people who want to get employment or get further in life without giving them even a slip of paper, and continuing that kind of a practice for years together. It's only when it is found out by an inspector or there is an accident that we come to know that no, what the register said was only 20 employees, but actually he had 100. Now, that kind of a situation is very bad, not only for the worker, but also for the country as a whole. We saw during the pandemic that there were hordes of people on the roads, and they had no legal nexus to the industry in which they were working. They were off the rolls. Now, and these were sweatshops in streets in the middle of the city. So I think that kind of a system cannot operate in a country like ours, and therefore the basic necessity of the time is that as and when a person is employed, he's given an appointment letter with basic terms of employment, and there is a notice put up on his facilities and benefits, so that the person is assured that yes, this employment will take care of me and my family for some time to come as per the terms.
Mr. Pagar, do you see any challenges on the appointment letter side? Because now appointment letter to everyone would actually mean that everybody's job description will also come there. So your earlier disputes, such as whether your workman was supervisor category or not, would actually get addressed by this appointment letter, which has a statutory force. Uh, Mr. Pagar, your views?
Certainly, the appointment letter will specify the person what he is working, because this person has to go by the not by the distinction by his work performance. Is a more important thing, because if we say the definition of employees and the workers, it differs it. So the person who has been employed in the company or in the smaller sector, smaller manufacturing company or non-manufacturing company, there is need to have a distinction of his work performance also, work perform also, because these two have to go together. So this makes a difference, because just by designation and not by the work performance will make a person vulnerable. So the question will, so the appointment letters issued to the worker will make effective, certainly, but there is need to have it, because in number of companies, especially the medium-sized sector companies and the smaller companies, rarely the appointment letters are being given to the workers. And today, the Shop and Establishment Act in Maharashtra and in the Tamil Nadu, it had the provision to issue the appointment letters. But how many appointment letters had we seen it?
Correct.
Very rarely. Only the big shops, appointment letters are being given. Smaller shops or smaller establishment is not been given. So monitoring of this system is need to be improved.
Sir,
and the action of the employer has to go fairly.
Sir, are you saying that there is an implementation challenge here?
Yes, certainly, his implementation challenge is there, because we have seen it. Employers on their own do very small things, but major things are done when the institutions is by either by the, I should say, it is by the unions or by the inspectorates. Those only things bring on the certain, to some extent, on the track.
Very well said, sir. I think, therefore,
Yes.
I think as Bagga Saab said, this is actually laying the field for bad shots. I mean, a very challenging aspect on the implementation side is what you are bringing it up.
Yes.
I'm going to move to another element and request you for your views. Annual health checkup above 45 years. 45 years, of course, is coming by way of rules.
Yes.
But annual health checkup being mandatory now.
Yes. Sir, this medical checkup is a most welcome clause in this OHS code. Because health of the worker is very important, because health of the human, health of the worker, health of the person is very important from the point of employer as well as from the point of his family also. Because what happens in the number of companies where if engineering companies there, manufacturing is less risk of health is there. But if it is chemical companies are there, dangerous operation companies are there, then the health of the worker is always at the risk. Either in the terms of the fumes, in the terms of the liquids, in terms of the leakages, all these things happens where the health of the worker is get deteriorated. And this deterioration in the health, because of the health hazards, in the industrial health hazards, will come to know only when his health checkup is been done by practicing medical practitioner. This one thing. And the health checkup is not just like health checkup. A format has been provided in the rules. The form number, what should say, the form number 9.
Yes.
No, not form number 9, not 9. Annual health checkups form. Is there, but exactly I don't remember it right now.
But it goes down to a very micro level. I mean, what is
I
it?
don't want to the micro level. And since that micro level has come down to us, yes. So exactly what is the health of the person, what precaution he should take.
Yeah.
So we'll come to know to the employer as well as to him also. And now the workers being are covered by the ESIC or by the health insurance schemes. They can take the treatment from the doctors or from the ESIC for improving their health, for maintaining their health, and which will give the help to the employer that if his workforce is healthy, so absenteeism will automatically get reduced, because many workers who tend to, where the industries are dangerous operations are there, absenteeism in those industries more than the engineering industry. If you analyze the things, the sickness is increasing in those industries. I mean, sickness is increasing. Naturally, the employer has to see the replacement of that person. So he has to pay the more extra money to the person who he is hiring it. So,
Okay.
so he will also get benefited. Worker will get benefited. His family will get benefited. So health checkup will make him to be maintainable and will be maintained person. I will not say the improved health, but his maintained health person will be there available for the person. And diseases occur only mostly after the 40 years of the age.
Sir, there is a, was there earlier provisions, especially when we talk about ESIC, about annual health checkup in any event?
Yes. No, annual health checkup was not mandatory.
It was not mandatory. Okay,
It
I
was
just
not
wanted
mandatory.
clarification.
Yeah, it was not mandatory. Now it has become mandatory.
Okay. There was a health checkup pre-employment.
Yes, health checkup but health checkup pre-employment, you see it is in a restricted way.
Okay.
It is not in the microwave.
Okay. No, I think this Form 5, which is kind of attached to the rules currently.
That form 5, sorry, I got it. The form 5 is there.
Yes. It,
Certificate annual medical health checkups. Form 5 is there.
it goes.
So
Suhas,
it is quite.
Yeah, sure, sir.
Suhas, one thing, by introduction of this provision, I think it is also an insurance to the employer that if he conducts this, he will not be taken by surprise on a occupational health claim. We have seen in the past that employees have steadfastly refused to submit to a medical checkup because even the unions have shielded them because knowing fully well that this gentleman or lady is
Unfit.
suffering from something serious, they would not submit to a medical checkup because then the continuous ill health, provision would come into effect and they could be separated. So I think it is a give and take kind of a situation where employer is bound to take care of the health and the employee, if he is suffering from a continuous ill health, should be discovered rather than exposing him to a hazardous process.
No, that's a very good balancing and fair point, sir. I remember that when I was working with Consumer Education Research Center at the beginning of the career, we were actually fighting a battle on asbestos manufacturing units. And I remember we had to go up to the Supreme Court to fight out to make it mandatory at least once in 2 years that the medical checkup be conducted. I mean, we were, of course, fighting for the ban of asbestos manufacturing because on the occupational health and safety grounds. But it was that kind of a fight. And now coming back to at a micro level, that and your employees' bilirubin count would be tracked every year, it's something which is a very, very heartening. And I think that's one area which kind of balances out various issues on the health and safety. So
Yeah.
that's a very good. Now, similarly, sir, a welcome move is actually employee accessing his own medical record. You pointed this out earlier, and I think this is one area which is an interesting area, but at the same time gives you a lot of comfort.
Yeah, because I think it's a privacy issue that the employer needs to safeguard health records of the employee and not to disseminate them further. But the person whose health record it is must have the right to access them and should know all the particulars. And I think it's a fair provision where the employee can access his medical records.
Thank you, sir. So I'm going to move to this safety committees. And Mr. Pagar, I'm going to request for your views first that these appear to be by and large bipartite safety committees today. Although there would be, when you look at the rules and go beyond section 22, you will find that the union representative would be there, contractors representative would be there. But still, by and large, this remains a bipartite safety committee. Uh, is this not a deviation from the earlier regime where you actually have uh, had in all critical establishments a labor officer there?
No, safety committee is provision for safety committee was already been in the today's factories act also is there. And
Correct.
it is very much, yes, it is already there. Even the, to some extent, the district disasters management committee is also there. District disaster management committees are also there. So it is at the local level as well as the district level also. So it plays an important role in safeguarding the that establishment as well as the surroundings of the surrounding to the establishments, and that helps the employer, at the same time the workers and the residential or other industries close to that establishment, to the close to that factory or to the mine or to that building and construction work site. So it helps it. But instead of having the bipartite committee, there could be a tripartite, inviting certain experts in the field of the safety, and especially safety in respect of the certain dangerous operations and hazardous operations systems. So it could have benefited a little more.
Yeah, that's my point. You see, sir.
Yes, they have. Yeah.
They
I
were
think,
yes,
sorry, I don't think safety is a negotiable point.
correct. Correct.
Number one. Number two, in the event there is any move by either party not to put in place a safe working environment or to block a safety issue, I think both parties, employers and employees, would be well within their rights to call in the labor inspectorate or the district magistrate. Because if it is a genuine issue, then none of the parties can actually block it, in my view.
I agree
So,
with you.
so just one thing I want to add it. So there is a provision for the third party audit is there.
Yes, yes.
Yes.
We'll come to.
Yeah.
We'll come to that,
Yeah.
sir. We'll come to that. On the audit side, we'll come. That's an interesting element.
No. My interest is that saying it. A person who is an auditor, who is a member of the audit committee, can be also make as a member of the safety committee.
Yes, yes. It should be part of it. See,
Because yes.
my experience is from various accidents and what has happened post the accident, predominantly right from Bhopal gas tragedy onwards. You see, sir, there was a provision on the paper to kind of have a stakeholders committee there broadly, because it was hazardous process, methyl isocyanate was there, and a host of things, but that remained merely on the paper. Now, so they're not even mandatory for it to be on paper. My concern is bit on those things, like what you said, that the employees and employers need to do the balancing act for their own safety is one element, which is fine from the occupational health and safety perspective. But as you rightly said, unless you make it mandatory, the employers don't fall in line. You
Yes.
continue to have every year accidents in Shivkasi on fireworks. You continue to have fatal accidents there, but there's no involvement of local stakeholders. You see, therefore, this was, in my view, this was an opportunity for the government to have come out with a far more better and a stricter regime when it comes to
Yes.
safety committees within the establishments, but it just kind of leaves it at the bipartite level. Having said that, sir, uh,
So
coming to,
we.
sure, sure,
So,
please.
just I may suggest to this one that we can recommend to the government on the basis of this webinar that instead of making the bipartite, let it make it tripartite, and the one who is a member of the audit committee of safety is there. So he can also become a member of the bipartite committee.
Yeah, sure. I think we can do that.
Yeah.
That's a good suggestion. Uh, moving ahead, of course, I think I'll not touch base, on grandparents being included in the part of the dependents. That's actually very good suggestion, because you are extending the dependencies and the coverage. And of course, we are also seeing the very young workforce today in India, and we'll come to that demographics subsequently. We're also seeing that there is a streamlining of definition in terms of workers, in terms of interstate migrant, cine workers, working journalists, all of them being clubbed together in what this enactment's objective talks about: consolidation, simplification, and uh, reorganization or rationalization, CSR as an objective. So 13 enactments have been bundled up together. But these are some of the areas which are good. But I'm going to come back to you on this, the inspector come facilitator. And sir, two questions around this. One, is it merely the change in terminology, or is it really in true sense facilitator would have the meaning of the term understood in English language? uh, uh, One.
Sir, so
Second, so
uh,
along with that, on the jurisdiction and the randomized allocation
inspection
that was
system.
already there in terms of audit or in terms of inspection, that seems to have now got a statutory recognition, or there is a statutory force for that randomized um, inspections. On these two counts, sir, I need your views, please.
So inspector cum facilitator, these two terms is always a different one, because the role of the inspector is to inspect it and ask the employer to correct it. A failure to correct it, legal action to be initiated. Whereas a facilitator, he will facilitate the employer to make the things to happen it in the right way. So what is the right way will be come to know only when it comes in existence.
Okay, sure.
Yeah, because unless we see that because it's after presuming that it comes after the 1st of April 2021, and in 22 or 23, when we take a review of the inspectors and the facilitators job profile, did it. So in the 23 probably, 2023, it will come to know whether the role of the facilitator has been made effective than the inspector's role, or inspector has become more effective than the facilitator.
Fair, sir.
So that time only will come to know, because this is a new phenomenon, new duties have been casted on them. So it will take time to decide whether inspector will perform better or a facilitator will perform better. Or who are going to be friendly with the employer, who are going to be friendly with the employees, who are going to be friendly with the unions. The time will decide right now. No. Okay. But now coming to the jurisdiction point, presuming that this fact comes to existence and the jurisdiction point will come, the jurisdiction point, the web portal systems has been introduced by the government for the inspection purposes. So there will be inspection. The inspection will be in 3 conditions. One probably will be once in 5 years. Second will be complaints, and third will be especially in the hazardous process industries. Probably there could be an annual inspection cum facilitation will be there. So yes, so that there should not be escape to the hazardous industry from the inspections. Otherwise, very bad situation may arise in respect of everybody in the countries. But when we talk about jurisdiction point of the view, so now it will become the no man's land for the inspector.
Okay.
Yes, it becomes no man's land for the inspectors. So inspectors will sit in the offices, presuming that the state is there, state's capital is there, either headquarters people should sit over there. The authority will decide who will visit to which establishments on the web portal systems at randomized system. So that part will go. Second, will a complaint will be there. So complaint will be given to the same officers. Dangerous operation will be there regularly. Inspection, probably the regular inspection will be there for the dangerous operation. So question will not come for that, but question will come for jurisdiction point only for the complaint cases and the web portals randomized systems. So when it becomes no man's land, so and inspection will be rarely, because now there is a quota to the inspectors.
Correct.
How much inspection he should do in the month. On the basis of that, his performance has been appraised. So naturally, there will not be a target to the inspectors that this much inspection he has to do it. It depends upon the authority to allot the cases to that
Allocation.
inspector,
Yeah.
and then he will perform it. But once that inspector been given to the name of that
Establishment.
work site, I will use the work site.
Okay.
It may be building construction, it may be mines in respect of central government,
Correct.
in maybe factory, it may be working journalist place, it may be contractor, whatever may be there. So he will do inspection once in all the acts
Okay.
where he has been authorized to conduct the inspections.
Okay, sir.
Yes.
I think, Suhas,
And probably there is a grouping of the inspector may be done.
Okay.
So inspector from the wages, inspector from the health and safety, inspector from the welfare, they will be inspector from the environment, they will be clubbed together and jointly they will inspect the establishment also. This possibility can be there.
Okay. No, that's interesting, sir. That's an
Yes.
interesting regime then.
Yes.
Okay. Bagga sir?
I think what is very heartening is that till now, there was no accountability of the inspectorate on what's happening in that area. The inspector was evaluated, as Mr. Pagar rightly said, on the number of cases he booked. And if he came away from the unit without a booking, he was charged that he's a corrupt person. I think that has to change, and that's what is being signaled. Because let's face it, most of the inspectors, I won't say all, most of the inspectors are very, very knowledgeable people.
Correct.
They can smell a hazard. They know how the best practices in the industry, what are they? But they're not charged today with the responsibility of disseminating knowledge. I think it is clearly a need of the hour that mindset must change. The mindset is not to prosecute and to fine people and to imprison them. The mindset should be how to make industry more safe in that area. And I think that will require a training effort by the government where these gentlemen and ladies are trained how to disseminate. They could even be charged with the responsibility of, let's say, you're taking safety. Now, safety has certain general tenets. They could be charged with the responsibility of conducting X number of training workshops of establishments in a particular area. And then, after helping the industry, if they still do not perform, that is the time when they must be penalized. And a case in point is really if most of us have been to Singapore and you see the cleanliness and hygiene in the eating places there, way ahead of what we have in India. And you will see a grading there. Now, the inspector is not only charged with fines and with penalties, but he is also responsible if the eatery, despite he has red cards and he has yellow cards. If after 2 or 3 yellow cards, he finds that the practice is still on, then he shows the red card. It's like football. So I think that mindset has to change. It should not be that because a union has complained, there is an inspection and this fellow is booked. Has he gone there? Has he studied? Has he interacted with the employers and the employees and tried to educate them? That, I think, is what is signaled by the change, which is very, very heartening.
Sir, just on a small point, is facilitator a mere nomenclature?
I don't think so. I think it's a real intent to make the industry stand up to safety and health requirements. And I think that's what I said. If you train the inspectors and orient them properly, I think you will see a sea change. Let me take you to the incident of Delhi. During the pandemic, there were 3 fires in Paharganj. Basically, the units were operating without a license. without any permission whatsoever, without any appointment letter. There were people who were there. Because of the fire, the workers could not even exit the plant because there were no exit routes. Now, if there was an inspector there, he should have been the first to be, put behind bars. Why did he not know? Everybody in the locality knew that there was a factory operating there. This gentleman did not know. Now, I think there has to be accountability on both sides
Correct. Correct.
for, because that incident also affects a good industrialist, because laws will get tighter and tighter and tighter. That's the problem.
No, no, I take your point, sir. I'm, I mean, I'm just going to quickly kind of comment upon, recognition of private rights of transgender. It's a very welcome move. I think it's a very good indication today that the legislature and the laws are coming out in recognition of transgender as the third gender or as the first gender in India, whichever way you look at it. But that's a very welcome legislative change that's coming up in the enactments. And sir, I think we all should welcome this. Sure.
Just one suggestion here, that if you're going to suggest to the government, I think similar rights must go to people with disabilities.
Disabilities. Sure,
Yeah,
sir.
so that there is special arrangements made for wheelchairs and disabilities. A lot of companies employ disabled people, and I think we must have good facilities for them, depending on what kind of disability they have.
Yeah, sure. Sir, please be with me because we're going to touch upon one of the large ticket items as we move forward is with respect to the contract labor. Risha, can we move ahead, please? And I think, sir, when we talk about contract labor, we are looking at what is it today. When we initially talked about contract labor, it was Abolition and Regulation Act. Now that act has been repealed. We're talking about, are we then saying that therefore uh, the concept of abolishing the contract labor itself is abolished now?
I think the code has the Act, Contract Labor Abolition and Regulation Act is subsumed in this code.
Correct.
So therefore, that act will go out of the legislative compass. What you have here, as is clearly mentioned on the slide, the abolition part of the earlier act has been dropped. So let me just explain it, if you wish, on what was the earlier regime. The government could have a advisory board, and most governments had an advisory board who continually looked at which are the areas in which employers were engaging contract labor. And if they found that certain sections of the society were being discriminated due to this provision for allowing contract labor, or there was misuse of the license granted for contract labor, they could abolish contract labor in that particular trade. For instance, one state passed or abolished that there will be no contract labor, let's say in loading, unloading. Or another state said there will be no contract labor in scavenging activities or in housekeeping, cleaning, etc. So this was a provision which was there, which has now been dropped. What has been done is, I think, very laudatory, and that is there is a clear code or provisions provided for grant of benefits, assuring wages under the other social security code, minimum wages and timely payment of wages, strict liability of the employer and the principal employer to not only grant wages but all the benefits. Even under this code, there are good provisions for ensuring welfare activities and for all the health and safety measures to be extended to contract labor. And there is a definition which allows contract labor in certain areas which are noted, and also those which are not areas which are not as defined as core activity. Now, let me give you an example. Let's see a unit that is making scooters. Now, if the unit is making scooters, is it required by law to make spark plugs as well? No, not really, because that's clearly a different industry and has developed as an ancillary industry for automobiles. So therefore, there could be parts of the final product which need not be manufactured by the uh, employer himself, or there are trades in the course of the manufacturing process. Let's say there are 1500 light poles in the factory. I do not have to keep a painter on my rolls to paint those light poles or to ensure that the bulbs are changed or the maintenance of those light bulbs and electric installations. I could well engage a reputed company like, let's say, Cisco or whatever, to take care of all the lighting establishments in my lighting units in my factory. That is now provided here. Now, those workers who come in from that other company like Cisco or L&T or whoever will be provided all safety and health measures, and also ensure that their wages are paid by the employer and all the benefits are extended to them. So I think what has happened by this provision of core activity is a clear flexibility provided for such people to come in who are specialists. Today, you do not have sweepers. Today, you do not have people who are, dealing with a particular, let's say, housekeeping function or disposal of waste, etc., etc. You have companies which will actually take away that responsibility as a whole and use the most modern techniques and equipment to deliver a full-fledged housekeeping and cleaning activities. Earlier, we required our own workers to clean the shop floor around their unit. Now, you may leave them that particular function and tell them to concentrate on the manufacture rather than on cleaning the floor before they exit the shift. So I think very, very progressive provisions, and there are safeguards to ensure that these are not misused. So I think it's a very, very nice step, which was already actually taken by Andhra and other states even earlier.
Sir, thank you very much for that, because I think, and we will come back to one other question that I have subsequently on this, is whether the core non-core actually is replacement to perennial, non-perennial kind of a function. But we'll come to that. Before we move on there, sir, I would just want views from Mr. Pagar. I think, sir, one, of course, I have been kind of looking at compliance certificates from most of the companies that employed contractors, and every time there used to be this issue that in your license you had sort of license for 20 people. At one point in time you employed 21, 22, and there is a violation. Now, sir, with one single license, all India license, on a portal, single 5-year license, will all these issues now go away? Because that makes it, that gives confidence to employers as well as contractors that the number may vary. Does this now give that confidence?
So there are basically, so there are three types of licenses. There are three types of contractors are there. One is to establishment wise, other is for work, specific work wise, and third is a all India basis or more than one state. So all three are covered under this provision of the Act, provided they have the employment of more than 50 contract laborers. Okay.
Correct.
So maximum number of workers to be engaged, to be employed by the contractor is to be decided by him only.
Yes.
It is always there that the provision always makes that maximum you have to mention it. If you cross beyond that,
Then there is violation.
actually you are contravening your own commitments.
Correct.
So naturally, the notice will be issued to the contractor. If we take the maximum number of workers, he employ more, less than that, the question of notice to him will not come at all.
That's
But now here, when we talk about the three type of the contractors, so all three type of the two contractors are basically the workplace contractors. So work counter basis contracts are there, annual contracts are there, and third is like a all India basis contractors is there. So if we talk about these first two contractors, so they will be specified within the state only. Probably they will not go beyond the state. So they have marked their own jurisdiction also where they will work over there. License can be issued for 5 years, subject to the 1,000 rupees as a security deposit per workers, and prescribed fees is there.
Correct. It's going up to 40,000.
Yes, going up to that. So whenever he will have it, so he has to intimate to the authority. Once he takes the license, he has to intimate the authority in the prescribed forma that this is a contract he has been awarded. So his date of commencement is there. So number of workers are there. This type of the work will be done by him. So those things formatting will be there.
Sir,
but when you come across with the all India license, because it is the first time this case has been coming up.
Correct.
Earlier, these things were not there.
So it probably eases out on the compliances, right?
It is of the compliance will be there, but let us wait for some few months.
Okay, sure.
Once this act will come, let us have little but more deliberations, because there are no specific guidelines are there.
Sir, now the definition has been tweaked.
Definition has been treated, but when a part of implementation will come, what the problems will come up.
I take your point, sir. Mike's slightly is a slight different question now. Is that since the definition has been tweaked today, the distinction that we were drawing, and as lawyers, we love drawing this distinction based on whatever were the judgments that came from Supreme Court onwards on the Contract Labor Act, is the distinction between contract for service and contract of service. Sir, that seems to have been addressed by virtue of this definition being tweaked. Would you see that it would now, with core, non-core, and with the definition being tweaked, this issue of classification contract for and contract of, will it go?
Probably yes, it will go off.
Bagga Sahab, what's your view on this?
I think if there is a palpable misuse of engagement of contract labor, I think there is enough scope in the definition to call that guy out. I think if there is any misuse of contract labor, because there is a framework that is provided here that this is what you will do to engage contract labor. If there is a violation of that or a departure from a clearly good practice that has been laid down, I think there will be bound to be action on that. So I think employers will be well advised, number one, to be very clear on the purpose for which engagement is happening, licensing, clear disclosure to the authorities by the contractor, what is the purpose, how many people, what kind of people there are, because they also need to disclose migrant and local people. So I think all these parameters will come into play, and any wrong disclosure or non-disclosure will be questioned. Any liberal statute also gets a regime which is tighter on the discipline of using that regime. So that must be borne in mind.
Take your point, sir. I think we are going to stop advising clients on this. Now this distinction between contract for and contract of. Contractor, register yourself, provide the same kind of working conditions to the contract employees and contract workers as well.
And you see, Suhas, the contractor is now an employer as well.
Correct.
To issue appointment letters, etc. So I think the principal employer can actually breathe easy if the fellow is a responsible person who has issued appointment letters and pays their wages in time.
No, that's very well said, sir. I think that is the big difference there, because the
Yeah.
principal employers, if they actually have this sigh of relief, then I think it will be very conducive ecosystem. But
Just I will add it to this one. Employers have the total benefits out of this contract labor system will be there, provided there is a compliance
Yeah,
correct,
of the provisions is there. What are the provisions are there? If contractor and he complies with that, there won't be any problem with the contract labor from the any enforcement authorities.
yes.
very
But
well said.
if either fails, problems will be there for both.
Both, yeah, very well said, sir. Very well said. I must kind of compliment you there. Very well said. Uh, Sir, moving on again, I think one of the changes that has come out, and probably I don't know whether it is a contextual change in view of COVID, is the interstate migrant workmen. Now suddenly you find direct recruits also uh, being qualified as interstate migrant workers. Do you see this also, going through a drastic change, Pagar sir?
Yes, it has gone to a very drastic change because earlier, what as the interstate migrant worker was defined, that's who is been recruited through a contractor
Correct.
and brought to the destination state from the origination state was the interstate migrant workman. So the one who coming on his own was not called as a interstate migrant worker, therefore was not being covered under the act itself. But now that has come into existence because of this code. So the one who is coming from the any other state than the to the destination state from the parent state is treated as a interstate migrant, provided he has going to have the earning of less than 18,000 rupees per month.
Yeah, I mean that is the definition of the
That yes,
worker there.
so
Sir,
it will be
but,
that.
sir, but once a migrant worker,
I was going to
if
come.
he stays out of his state, he is a migrant for life.
Yes. Yeah, that is right, sir. That is the right way you are saying it. I do agree with you because once somebody leaves his state, he is a migrator to the other state and he becomes a migrant to the destination state. But how long he will become destination state?
Sir, people like me have never worked in my own state. So,
Yeah. So you are it is,
And
but it is in large. It is large number of people are there.
absolutely.
we
So
keep
there
on,
is
But I
that.
don't think it's required because
Uh,
there was no measure available with the government to separate the people on the road from normal citizen.
sir, it is contextual in that sense because this issue came up during COVID and
But
pandemic.
what with this interstate migrant worker, just I will add furthermore that the parent state he has to know, he has to intimate to the parent state that I am living to the particular to the destination state, this state, and he has to inform to the destination state that I am employed with this company to the designated authorities. So there is a declaration has to be done by him also.
Sir, I think yes, but the moot question again is that how long does somebody continue to be a migrant?
There is no bark.
There's
There is no bark.
There's no clarity because
There is no bark now.
yeah, because now what has happened is that every employer will have to give a to and fro journey
Yes.
and will have to pay for that to and fro journey once in a year. I'm sorry, I've
Yeah.
mentioned here every 12 months, but I think the law says once in a year.
Once in a year.
Once in a calendar year, at least, you will have to make sure that your migrant workman goes back to his state. No, sir. So the cost is going to increase for sure. And secondly, the migrant worker, how long? I mean, how many years do we continue to, as employers, do we continue to pay for the to and fro? That's still a question.
So there is little bit I will add to this. This is a very fun part here. Huh? If minimum requirement is that he should work for not less than 180 days in a year. Okay.
Correct.
Part of the year, presuming that somebody has worked in the 8 months with ex-employer, he leaves with that employer, he goes with the Y employer, rest of the 4 months.
Correct.
So the new employer has to pay these to and fro charges.
Yes. I mean, it's going to be nightmare.
Nightmare one thing, yes.
But sir, it's a very good beginning. I think although COVID has kind of prompted this to happen.
Yes.
But at least at the all India level, there will be interstate migrant workers directory available, or registry available. I think that's a very good sign. Sir, I'm
Yes.
going to come back. I'm going to come back to a couple of things which are bothering me personally. Whenever we've kind of read this code and the rules, the terminology of employees and workers have been interchangeably used. You know, at some places it is written workers are employed, and at some places it is written employees are working. Notwithstanding the English language, I think from an interpretation perspective, this is bound to create certain problems. There are various such things that we can talk about, but that's one area as to why simply in kind of uh, doing a correct or undertaking drafting in a proper manner, this could have been avoided. Don't you think that this could have been avoided?
Yeah, certainly. I think it's a hurried drafting job, but I think these issues will be, thrown up soon, and I think they will come up with amendments as we go along.
Sure. I think, sir, two other comments around this is one, I think there are 89 elements where they have said we will prescribe it, and it will be prescribed in the rules. We've seen the central rules and central draft rules. I think some of the elements are missed out, but probably would get covered in the subsequent rules. But the issue is again a large issue on the principle of delegated legislation, sir. How could substantive elements of law be left to the rules while the act remains silent?
I think as is the law that the provision that they make is a number or a stipulation, or the rules cannot override the act.
Act.
So therefore, the framework is provided. It is adding flesh and hair to the provision, which is fine. And I think there's a definite advantage here because for the central government, because there is bound to be center and state conflict in the rule making. Now, the state cannot overshoot the main legislation.
Yeah.
They can provide rules only in that area which
Yeah.
is left to them. So that is I think good, and that will bring clarity and uniformity across the country. Yeah, Tamil Nadu will provide it in Tamil and Maharashtra will provide it in Marathi. No problem.
No,
But
that's fine, sir. But how could substantive elements be left to rule making authority?
because it's getting into a stage where the wage limit, the things like that, the coverage areas are changing so fast, and there is no updation happening at all because you are dealing with the Factories Act of 1950s. Now,
That's true. That point is well taken, sir.
they have not even touched it since 1950, which is also equally bad.
Yeah, that's true. That's true. I mean, that
Yeah.
point is very well taken, sir. Again, I think there are some kind of issues inherent in terms of consolidation of diverse laws, uh, and the workers and employees intermingling is one such element. But sir, a very welcome step is actually electronic maintenance of records, because earlier regime we had to look at what was the state law, and we had to get exemptions from state to state to dispense with physical records and move into electronic records. But that's appears to be one big move on transparency and simplification. uh, Sir, your views on electronic records and also
No,
electronic filings?
this is a very much welcome steps and taken by in this code. Since 2012 and 2013, we are working on this. Even in the past regime, also work was started to maintenance of the electronic format records. Now it has taken a space in the 2015 by making the amendments to the rules to the acts itself only. That electronic record keeping was been allowed. It's been there, and the continuous progressive is there. But now here in this code, if you see it, nothing has been kept as a manual one year. All communication requires to be given in the electronic and digital way only. So the reduction in the manpower is getting reduced, time lapse has been reduced. Then when communication is being received by the employer, by employee, by the authority, will be exactly decoding, you will be come to know. Because no one can say that, no, I have not seen the record, I have not seen the letter, I have not seen the return. These things will go off. So this is a very much welcome, and in the today's situation of electronical media, it is most welcome things.
No, thank you, sir. I think I'm running a bit out of time, so I'm going to expedite a bit.
Yes.
Can we see one small bit I will mention, and then we can move to the next slide? Is, you see, sir, the compounding. Now there is a electronic filing for compounding under the rules that have been provided. But most importantly, I think in terms of compounding of the offense, uh, you see very clearly, the law now says that the person who is compounding the offense shall be discharged,
Yes.
which is slightly different, sir. As a student of law in IPC and CRPC, compounding actually means acquittal and not discharge. Here it will be discharged. Therefore, the subsequent question about whether
No, no. Sir, I would like to differ. Compounding never meant acquittal. Compounding means admission of the
admission of
offense,
guilt, yeah,
exoneration because of paying the fine instead of going to jail. So it was, I think the term discharge is fine.
is fine. Okay, fine.
Yeah.
I'll kind of talk to you later on offline on this, but let's move ahead.
Yes.
I think very clearly there is an issue about coverage, and I think Mr. Arun Kulkarni in his chat box kind of picked this up. When we're talking about, sir, only social security fund for unorganized workers, uh, did we lose out on the opportunity to bring in unorganized workers into the main fold? Because government itself recognized that there's only 1.66% of workforce are these establishments where there are more than 10 workers. So the unorganized labor seem to have been completely left out. Could it have been brought in? Because when we talk about safety, and when we talk about health and safety of workmen or at workplace, I think it is but a must that you need to treat organized and unorganized sector on the same footing. On the health.
No,
So here it's,
you must realize that unorganized labor is in areas like agriculture and total commercial activity in the markets and things like that. Now you cannot expect a farmer to set in place SHE facilities and things like that. Now, if these codes are only for organized industrial activity, not for unorganized industrial activity.
No, sir, within organized also, why differentiate between 10, more than 10 and less than 10?
No. So therefore, if let us say there is an exemption for residential or domestic servant,
active servants.
now I don't think the labor inspectorate is enabled to handle each and every household. You see, if you come to my house, there is a register of complaints against the maid, which the labor inspector will not be able to deal with at all.
No,
It
sir.
is
Sir, I'm not on that. See, the modality could slightly be different. I'm not on the modality part of it. You see, for example, there are various establishments. I'm not talking about residences. Establishments that employ less than 10 workers.
Sir. So there is a minimum threshold over which this legislation applies. Now, below that are legislations like shop and establishments and others, which take care, the state legislations take care of those establishments. But this is a specialized, it's a very professional code which requires the latest in industrial activity techniques and manufacturing practices and things like that. You cannot expect a shopkeeper with 2 or 3 people to deal with the intricate provisions of this code. And that's why I think they've been kept out.
Pagar sahab, your views, because I beg to differ there.
No, no, the reason is for the unorganized establishments are being a smaller, very smaller establishment, and where the causes of the health and safety very rarely occurs. But in a major, when we talk about the bigger establishments and bigger work sites, the possibility of the major health hazards and the safety requirements are much more needed. Whereas these things are very shortly, lessly required in this unorganized sector waste work sites. Even there are 123 employments have been categorized as unorganized labors, unorganized sectors, 123. But where the employment is less than 10 people. So the employer who is employing less than 10 people, naturally he himself works over there.
No, no, sir. Does that entitle you to differentiate between one human being and another human being when it comes to issues such as safety at workplace?
Now here the safety will not come at more, because safety at a bigger workplace is more
Is not as
than is this one. Because
it's not
there
as
is always a distinction has to be made out. Distinction has to be made out. Because affordability and require and necessity, both are necessary, cannot be are not required in the smaller section.
Sir, I mean, yes, there could be a debate about it, but I'm not convinced that this ought to kind of be distinguished on the manner of why 10, why not 5, why not 15, why not 20. For example, if you look at the factories, uh, uh, which are kind of, if you look at the manner in which this is being defined, you see, it will exclude the factories which is employing 10 to 20 men, with the aid of the power, and in case of plantation, 5 hectares.
Right.
It's above 5 hectares. So, sir, if there is factory less than 20 not employing power, will be out. Now, when
That's it. That's
They have
okay.
to follow establishment act.
You see, Suhas, you see the intricate responsibilities of the employer under this legislation and the registers and the forms, etc., etc. If that small shopkeeper is burdened with this, that poor chap will have to close his shop and keep making registers instead. So that's the problem. And I think there is a principle of de minimis, and this is the way it operates across the world. It is always there is always a threshold over which the legislations of this kind apply. Take GST for instance. You can well question why is GST not applicable to the small trader, but that's the way they have decided it to be, and it's a reasonable classification, I guess.
sir, on the fiscal side, I completely agree with you. When you talk about fundamental issues such as individual safety and health, should that distinction be there?
So the general law of the land will come into play there. Plus, there are other legislations like minimum wages and Top Act, etc., will come in.
We'll have to look at how that meshes is up. But moving ahead, I think one of the areas that I'm really concerned about is the hazardous processes and the manner in which this act deals with hazardous industries. You see, can we move ahead, Risha? Uh, there are it is a list of about 40 industries, by and large classified as 28 or 26 processes there. Sorry, am I audible?
Yeah.
Yeah, audible. Yeah.
Okay. So I think when we talk about hazards, there is a definition of a hazardous substance, there is a definition of hazardous process, and it is a list which contains about 40 industries. Coverage when it comes to hazardous process, it's streamlined, and I think the law agrees with me there that even if it's a hazardous process where
Less than 10 people.
less than 10 employees are there, we need to focus on their uh, health and safety. You see, therefore, how do you look at, and in India, I think right from Bhopal gas tragedy onwards, there have been instances and there have been accidents, and there is no lapse, there is no recompass on these accidents, and periodically they go on happening. The fatalities numbers are very high whenever anything of this nature happens in the hazard. Now, just move ahead, Risha. Going ahead, I think my point is that you see the manner in which this enactment deals with hazardous process and hazardous industries is a step below the current provision in terms of Factories Act, especially when we talk about the limit of exposure of chemical and toxic substances. You see, the thresholds have not been provided. Under Factories Act, sir, we all know there is a threshold that has been provided. Although there is an elbow room available to say that probably this would be governed by the processes and this would be governed by the subsequent rules. My point is, sir, that when you talk about in your statement of object and reason that we're talking about a dynamic um, adoption of dynamic factors, looking at technological changes, the original list hasn't changed of hazardous processes. Secondly, there is no intermesh between the technologies that are today available, which probably could have avoided not only Bhopal gas tragedy, but the Vizag tragedy could have been avoided had there been a good um, law that talked about meshing technologies to avoid hazardous accidents. Sir, your views.
I think the onus has been put on the manufacturer by the wider definitions of hazards and the responsibilities on safety and health which have been included. It would have been nice if there was a comprehensive provisions on the kind of hazards we want to control and also their fallout. So either you uh, go on the charging clause in on safety and health. If you go there, it's an all-encompassing liability. I think the onus is really on the manufacturer or the employer to ensure that the hazards are well defined in the factory and the safety regime put into the unit is responsive and all encompassing all the risks that exist on that manufacturing process. So I think that responsibility has been clearly put on the manufacturer. However, I totally agree with you that the list seems to be outdated and it is just a cut and paste job really on that aspect.
Sir, my point is, moving, I mean, taking it to the next step is, you see, the permissible limit for exposure of chemical and toxic substances, which was the provision under the Factories Act, is completely missing out today. So you have, let's say, you have a safety committee, you have uh, given right to the worker or an employee to complain about something going wrong. If this basic provision is not there with respect to the exposure, I think even if he complains somewhere, the things are going to go awry.
I
It's a
agree with you. I totally agree with you.
step backward in my view.
Yes.
I think if there was a provision of that kind, it was providing some kind of a guidance to the manufacturer or the employer. But here, I think the field is open for legal, battles and things like that.
Pagar sab, your views on
Yeah.
this?
So certainly I agree with the Bhagat sir also because litigation it is a ground for litigations.
Sir, secondly, one of the very clear elements when it comes to hazardous process, and I think that was fundamental issue. I'm not sure whether it was there in Vizag or not, but it was definitely there in Bhopal, which was actually the locational clearance given to the factory. The locational clearance was given on the north end of the town, and it was based on that locational clearance that the winds blow from north to south and the entire town got affected, upper town got affected. Sir, now today there is a site appraisal committee and there is a locational recommendation, but where does that go? It's the law doesn't specify today. The code doesn't specify. It only says that yes, there will be site appraisal committee before granting the permission for the hazardous substance manufacturer. But what happens to that subsequently is a huge question mark. That's
I think so as they may be riding on the environment protection
environment
rules
protection. Correct.
because there are very stringent provisions on where to locate hazardous industries. So they may be of the view that since it is covered comprehensively in an expert or in an appointed legislation, we need not provide it here.
Yeah, probably. But then why have a site appraisal committee here? I mean, if the appraisal is going to happen there,
They forgot to cut it.
they forgot to cut. Good one, sir, good one. Okay, just another kind of a issue there is it's no longer a duty of the employee or the workman. Actually, when it comes to hazardous process, it gives them right to warn the employer
Yes.
and the inspector and facilitator about the imminent danger that could happen. So from that perspective, it's a very welcome issue. Now, sir, you look at what happens in terms of penalties and prosecution as a consequence of something going awry. I think, sir, if you're talking in terms of maximizing penalty to 20 lakh and 3-year jail term, is it deterrent enough would be the question. But I'm not going to kind of talk about it. But there's a very good kind of analysis today, which has come out saying that when you talk about chemical hazardous substances such as methyl isocyanate and phosgene and styrene, styrene was Vizag, methyl isocyanate was Bhopal. I think the chemical engineers seem to be suggesting if some one thing has to go wrong, everything goes wrong subsequently in that, and it amounts to a huge kind of a colossal issue on human negligence as well. But sir, this is one grave concern where I think this code, in my view, ought to have done far better.
I think, Suhas, another aspect of concern here is that there are a host of industries in India and indeed everywhere where the technology deployed could be the same vintage as the earlier Factories Act. So
Yes.
since 1950, the same plant has been producing certain products, and the technology is not upgraded, and the safety systems are not upgraded. I would have, it's like the cars on the road. There is no time limit to which you can ply a car. So now I think there has to be also certain provisions on review and renewal of
Yeah, yeah.
certain kinds of industries which can lead to hazards like Bhopal after some time, because there will be aging of the plant, and there could be more leaks and more accidents.
Absolutely, sir. I completely agree with you. And I think that from that perspective, this is completely missed out opportunity on this code. Sir,
Maybe
coming,
maybe the audits will take care of that, I guess.
let's hope, sir, let's hope. And that's where we look at inspection and audits as one of the areas where what seems to be happening now is that, and I think Pagar Saab was kind enough to explain the randomized selection and the manner in which the audit becomes one of the key performance indicator for inspectors in the earlier regime. Probably that's gone. But sir, building this capacity through third-party auditor, I'm going to only touch upon two elements out of this. One is building this capacity through third-party auditors. Till even now, it seems that it's only the smaller establishments that will go through third-party audit. Is my reading correct, Pagar sir?
Smaller factories and medium-sized factories go more on this one,
On
third-party audits.
third-party
Yeah.
audit.
Third-party audits, the medium-sized industries go more than the larger, because larger have their own internal inspection systems. But in many cases, the ignorance has been given.
Okay.
Yeah.
But sir, was it not? I mean, we today have third parties which have been kind
Yes.
of designated, qualified, recognized
Yes.
by the state governments. I believe, they will continue here as well.
So yes, they will continue to be like your chartered accountant who is doing your audits of the financial audit of the companies.
Correct.
And that is being taken as a certified audit of the company, and that is being placed before the any authority in the country. Same way,
Correct.
this audit expert safety committee will be there, because in safety committee, in transport safety committees are there. Everywhere safety experts are there.
Yeah.
So their views and their implementation, because not only on the paper expertizations, actual expertization is must necessary.
Correct. Sir, now let's look at one other element here, which probably is a new element that's coming up. which is really this notice for improvement. See,
Yes.
notice for prohibition post inspection, one can understand and agree with. But there is another element that has come up, which is notice for improvement, which is a tremendous welcome move. Because if I were to
Yes.
draw a parallel from any other enactment, it's under the FSSAI that there is this notice to improve. And unless you give notice to improve, you can't really go back and force a company
Prohibit it.
to
You cannot
reform.
go for the prohibitions.
Yeah, there is a food supply chain there, and here there is a complete risk analysis that has to be done. So the improvement notice appears to be a very good kind of a suggestion that has come in as a part of the inspection and audits.
This is the facilitation part actually. The
No sir, no sir, facilitation quote unquote will go a different term.
no. I'm saying the inspectorate as facilitators, the improvement notice is actually a step in that same direction.
Correct, correct.
It is for the compliance. Basically, it is for the compliance.
Yes,
Yes.
yes.
Okay. Now, therefore, there is a recognition under the code that we do not have enough inspectors or auditors.
Yes.
On two counts. One, there is a threshold of 1020 that has been provided. Second, there is this issue about third party auditors being encouraged, or let's say provision being made. So there is a lack of capacity when we talk about the inspectors and auditors. Now, sir,
Not really, not really. I think it's empowerment of the industry to take action on its own rather than bank on the inspectorate to bang them on the knuckles. I think third party auditors is a facilitation, not a admission of this one.
sir, no, sir. The third-party auditors, it may not be admission of lack of capacity, but the fact still remains that the third-party auditors are being called today. The provision under the code is only for small factories, and
Yeah.
only for small establishments. Having said that, sir,
You don't want to actually impose too much of cost also, no, on that small manufacturer.
my view is, sir, that you see, will the knee-jerk reaction post-accident continue? Because we don't have enough manpower, notwithstanding the third parties coming in. Because it's only post the accident that happens that somebody will knock and somebody will take something seriously.
So that is the way you operate. That is your history. So that cannot change.
Okay,
You bring a legislation only after a debacle, na?
good, sir.
Yeah.
Fair point taken. See,
Yeah.
one of the very interesting elements and one of the very heartening element is that there is a confidentiality qua the inspectors and the auditors,
Yes.
and that confidentiality with respect to processes, with respect to registers, with respect to documents and working processes is all today recognized as a statutory right, notwithstanding the authority being inspector and facilitator or chief inspector and facilitator. I think they have said that the authority will not disclose any confidential processes if it has come during the course of their inspection. That's a very good kind of uh,
Yes.
provision which is there. Therefore, there is a recognition to the confidentiality through the statutory process today. Now, uh, when we talk about right to information, because I think that was one area which actually gave confidence that the unwarranted practices actually went off, because right right to information actually paved way for uh, lessening the corruption in all inspectorates across various industry sectors, and not only labor and welfare. But sir, there is a complainant's right as a confidential whistleblower that's being maintained. That's also a very welcome step currently on the
Yes.
inspection and audits. Very quickly moving ahead, you see, sir, I want to look at Risha. Can we move ahead? I want to look at you know unified annual return, um, sir. Very quickly. I mean, this is like the
Hmm.
rapid fire because I think I'm moving out of time. So I want to look at unified annual return, sir. Your views, Bagasa?
No, absolutely progressive.
Right. It's a
And I
progress.
think it's great to have one stop shop rather than 15 reports.
Okay, Pagar Saab?
No, it's a welcome move, certainly, because it will reduce the paperwork of the employers also.
Okay.
And
Now,
it is this and second part, this being provided in the electronic format only. So analysis of that for any information can be done by this inspector's level.
Sir,
To have
automatically
the,
be generated. Automatically.
it will automatically generate it, and it will make beneficial to the policymakers of the country.
Yes. Yes.
sir, from that perspective, I think this one code stands out amongst all four, because
Yes.
this is where the unified annual return across
Yes.
all four codes is determined.
Yes.
Has to be filed by April end, and smartly
February 8. February 8.
February end, sorry, and it smartly says on February 28th or 29th as may be applicable, which is fine. Secondly, I think contracting out, if there are more favorable terms and conditions, we all
Yes.
agree that this is one provision which will be a heartening provision for employers who want to do good. And
No, this provision already in all the law acts.
yeah, it is there and it continues.
Mostly, most of the act it is there.
Correct. Sir, on the holidays and leaves, I think prefix, suffix, and
That is, yes.
that's gone.
Suffix prefix is gone.
The-
No,
So
no,
it's
not only prefix, suffix, but the holiday falling within the leave also has gone.
has gone. So
Yes.
effectively, the number of days, number of working days will be reduced.
No, not only reduced,
nothing.
you have leave applications only around holidays.
Only around holidays. So you'll have, like what happens in most of the Western countries during Christmas period, everybody is off. Is likely to happen here during Diwali now.
Yes.
Okay. Sir, there is a deemed registration that's being provided on the unified registration, or let's say electronic registration, and within 7 days, good kind of a process. I have not followed one thing, sir, when it comes to overtime payments. You see, we thought wage code will determine with overtime payments. Wage code talks about, and in section 14 it says payment of overtime only to those employees whose rates are fixed under minimum wages. However, talk about section 27 in this code, it talks about extra wages for overtime and its applicability is to the workers. So obviously 18,000 is the threshold limit there.
Yeah, true.
Why should overtime come here?
No. So just a minute. 18,000 threshold for the workers is a other thing. It is only for supervisors, not for the workers.
No, I agree. I agree with you, sir. I agree with you.
So a little bit differences.
I'm saying, therefore, the overtime payment is not applicable to everybody.
To
No. So over.
overtime payment will be available to every worker, all the workers working in the factory. Even they may be drawing more than 18,000 rupees workers, 18,000 rupees payments.
Okay.
Only the exclusion is that the supervisors who are drawing more than 18,000 will be excluded.
Okay.
Yes.
So Suhas, overtime actually is a measure to safeguard health of the worker. It's not a remuneration. Number one, so that you have spread over and all that. So you cannot ask the employee to continue to work if the relief has not come. That is why these penalties are fixed. So I think it's fine, absolutely fine.
Yes.
Fair point, sir. I take your interpretation of stretching it to say that, working for 120 hours in one quarter,
25, yeah.
maximum prescribed, which is fine. Secondly, sir, now bonus or calculation of bonus under the wage code, you have accounting here because you talk about allocable surplus, you talk about
Available and local.
available and allocable. So therefore, there is accounting here. Except for bonus, everywhere else it is calculated.
Yeah.
Calendar year. Most of the place it is calendar years.
Yeah. So abroad, even the accounts are maintained on a calendar year basis.
Correct, sir. Correct.
It's only in India, one of the few countries where it is April to March. So therefore, when it comes to money, it is bonus. When it comes to real life, it is like rest of the world.
Fair point, sir. Just a minor point, but I wanted to highlight that. Of course, we discussed about contract labor and interstate migrant workers, the kind of core, non-core issue giving rise to the non-perennial and perennial nature of work which was there in the earlier regime. Can we move ahead, please? I think, sir, my view is that vocational training, etc., has taken a backseat. It's probably a missed opportunity. See, this is just my view of looking at things, and we will then open up for question answers very quickly. I'm saying this appears to be a missed opportunity here. We have a young population between 2020 and 2039. The average age of the worker or average working age in India is going to be between 25 to 29. You see, we have only 2% of Indian working population that is skilled, and I think this code has probably a missed opportunity insofar as the skilling, insofar as various elements of the job that we are foreseeing today. From that perspective, I think I look at this enactment as ossification of Indian labor laws, that it will continue to force us and the employers as well as employees to look beyond the enactment and to kind of find our own way of working, uh, which probably could be more beneficial, and we will have that ability to contract out of the employment. In view of the current scenario where I think the jobs are at risk today, there is a variability in pay, wage variability. A lot of people have asked me as to why these none of these codes talk about work from home and the current scenario, although the context has pushed this discussion. But there is a huge gap today in terms of skilled and non-skilled workmen. I think this uh, this code, in my personal view, actually misses this opportunity out. We have to look at what is the next gen employment, what is the next gen workforce today, and this is not engaging that future workplaces. This is not, in my view, a legislation that looks at future workplaces. It has tweaked the existing law, but I think that's only my personal view. I'm going to request your concluding remarks, Pagar Saab, and then Mr. Bagga, and we'll open up for questions.
You can take the slide out, I guess.
Sir, yeah, before we do that, I just want to kind of express and go up, Risha, to the next slide. Next slide, please, Risha. I just want to.
Risha, yeah, Risha has internet issues, I guess.
Okay,
She's locked up.
I just wanted to thank the team. I just want to thank Jaideep Keval Ramani, Jyoti Chaudhary, Risha, Mehak, and the entire team for supporting us with the research and a very sharp presentation here. But sir, concluding remarks from both of you.
Mr. Pagar.
Mr. Pagar, concluding remarks from you.
Pagar sir, you are on mute, sir.
Pagar sir, we are not able to hear you.
No, his microphone is on.
Yeah, there's some problem. Sir, do you want to go first? And then we'll see.
Okay. So I think being a practitioner of, as they used to call it, labor law for a long time, and have closely watched the development of the regime on labor law in India, right from a time in the 40s, 50s, though I was not around at that time, but from 40s to 80s, nobody touched the labor law. It was during the emergency that labor laws were tweaked and made tighter. After the emergency was lifted and there was a huge hue and cry, what happened, and everybody deplored it. But then the changes in labor laws were never rolled back in totality. Now, it was therefore the employer's dream that one day somebody will touch and change the labor laws. Here comes 2020, the worst year possible, when the labor laws get unified and converge. So the compliances have reduced in number. The provisions for compounding have come, which were unthinkable earlier. Even if your notice was torn on the notice board, you could be fined and jailed and things like that. Now, that kind of regime has shifted. I'm sure if you go through all the codes, and we have gone through 3 codes, their gates have been left open for governments to prescribe better ways or to prescribe working rules. I'm sure with more and more interaction happening, there will be a softening of stance, and all we don't want softening on safety, health, and
Correct.
environment. But what we want is a regime that is helpful and recognizes the efforts that are being put in. There could still be accidents despite all the technology and all the effort and all the training that happens. Yes, but to take a pragmatic view, to periodically engage and update the systems, etc. And I think it's a heartening step that has been taken, and we all welcome it. And I'm sure as the time progresses, we'll have more and more, scientific and relevant to the times kind of laws that come in. Thank you.
Thank you. Thank you, sir. Thank you very much. Pagar Saab, your concluding remarks? No, sir, we're not able to hear you.
So do you want to rejoin Pakasa? Pakasa, can you hear us?
No, we can't hear you, sir.
So can you rejoin again the meeting and rejoin?
I think, Suhas, what
Yeah.
I suggest is you can SMS him to rejoin,
Yeah.
and meanwhile, we can start taking questions. He can rejoin, and then we can get back to that.
Yeah, I'll just call him up and
Yeah, please do.
get it out.
Yeah, sure. In the meanwhile, I think we'll just look at some of the questions. The first question from Renius is, dear speakers, can you also clarify how OSH and WC code will relate to establishment covered by Shops and Establishments Act? The code is not repealing S&E Act, but what is the relationship then with regard to Shop and Establishment Act in your views? Bhaga sir, you touched upon it. Do you want to?
Yeah, so Shop and Establishment Act is a state legislation which is not being subsumed in this code. So if you are covered by this code, you will have to live by this code. And if you're not covered here and you are covered by the Shop Act, you will have to follow that. And if you're covered by both, you will have to follow both.
That's a good one. Good. Sir, the second question is, health checkup only for ESIC eligible employees? Obviously, no. I think it's kind of mandated for all employees today. That's question from Niharika Srivastav. Niharika is also asked saying, is this mandatory for all industry or only specific industry or factories? I think as we see it, the health checkup, annual health checkup is mandatory for everybody, all establishments, not only specific industries. There's a question from Mr. Nandeshwar. Is the code applicable to service industry and data center employees?
There is an exclusion for IT companies in the definition of industry. If you fall within that, exclusion, then you are out of it.
Yeah. Uh, okay. Then the annual health checkup of employees is positive step. However, will it not lead to fire the employee on the basis of health checkup as well? Again, Mr. Nandishwar's question.
I think if it falls within your established principles of continued ill health and and unable to perform the job functions, then it could lead to termination or retrenchment.
There's a question from Mr. Srihari Lele. For work from home anywhere, what is the workplace?
That has not been dealt with in this particular legislation, but there is a provision under certain other codes for that. So I think it's an evolving space, and the government will possibly come up with regulations on that.
Thank you, sir. Pagar Sab, can you hear us?
Yeah.
Can we hear you?
Oh yeah, I hear you, but I think now you are hearing me.
Yes, you
Yes.
Okay, fine. That's okay then. Okay.
Sir, please, I would request for your concluding remarks.
Ah,
We are in the midst of Q&A, but we'll continue with Q&A. Sir, please.
okay. No, sir. Basically, since the 1991, the liberalization started in the country, since then the talk of the flexibility in the labor laws to be brought was discussed. But in the 1999, when the second labor commission was been installed, the second labor commission recommended this 4 crores plus unorganized workers security fund, and that has been materialized in the 2019 and 2020. Now in the 2020, when we talk about the 4 labor codes, all these 4 labor codes are given the base and the pace for the employer and for the workers. Probably the unions are not happy with this one, but the employers' contention is still not been known, because are they being getting through with it or not? So it is to be again observed.
Okay, sir. I think we will have a webinar after about 1 year of implementation and see what happens.
Certain, yeah, we'll see. Certain, yes. Only will.
Because I think
That
that's
is what,
one
yes.
area where I
Yes.
think the interesting part of it. Thank you very much, sir. Thanks a lot. But continuing with the questions, I think there is a question from Bikash Rath. I think part-time workers are not contract laborers, and the third-party employees, example team leads, etc., are not contract laborers. Can this part-time workers and third-party workers do the core activities of the establishment?
Under
Basically,
the new definition of contract workers, there are certain activities which are provided which can be farmed out to contract labor. Now, if team lease is performing a function which is covered there, then it will be a contract labor activity. However, if it is an activity beyond that, then it may or may not be. Because I think the definition of contract labor is very clear. And if the core activity is what has been farmed out, that is clearly not allowed. If you are in the business of, let us say, publishing books, and the person is in that publishing aspect of the business, then it may or may not be allowed.
Thank you, sir. Thank you for that. Again, Mr. Rutt's follow-up question is, outworkers now contract workers as per definition, as it is not excluded in the previous definition. Hence now, outsourcing activities by the contractor shall be considered as contract labor. That's his question, whether the outsourcing activities would be considered as contract labor. This contractor needs to have a labor license.
yes,
I mean,
outsourcing itself is a contract.
No. Sir, what he's saying is the contractor is outsourcing further.
Contractor is outsourcing further. Naturally, is a subcontracting. Subcontractor is covered under the Contract Labor Act.
Absolutely. So both will have to take a license.
Both will have to take it.
Both will have to take the license.
Yes.
There's another question from Mr. Srihari Lele, very interesting one. He's saying the third-party audits, does it mean ISO 40005 2018, OSHA's management system, which is 18001 2007, I think my take on reading of this code is that, you see, it's missed out an opportunity to mesh this up with ISO.
I
Pagar
think
sir?
they did not want to
Yeah.
make it as onerous as that, but if you are doing that audit, which is a certified audit, that will be great because that will be above par. But the code leaves it to you to decide.
Sir,
No, no.
Pagar sir,
Yes.
your view?
Sir, the issue, what was the question?
No, the third party audit, does it
Ah,
mean ISOs?
no, third party audit is for the safety committee. It is third party audit is for the safety purposes. So
Correct.
safety purposes is altogether different from the ISO audits.
Yeah. I mean, ISO audits are
Yeah.
totally different.
Altogether different. ISO covers a lot of other things.
Correct.
Whereas safety, this third party audit for the safety is fully for the safety purposes.
No, certain ISO audits cover safety as well. So if
But
that
it
is
can become, so that can be third party then for
yes,
the safety committee, safety purpose. Yes, certainly.
Sir, my view is
Yes.
that ISO is way far ahead from what the safety standards are.
absolutely, absolutely.
Okay.
My view is there was an opportunity to standardize this space by bringing in that recognition to ISOs under the Act.
That's
Which is
fine.
what happened. Anyway, sir, thank you very much for that question, Mr. Lele. We'll move ahead to Mr. Arun Kulkarni saying, do panelists think that these changes in law will give comfort to the investor from outside? Uh, Mr. Pagar, sir, do you want to take that first?
Because labor is not only the single front for the investors. Number of other fronts are there for the investors. Labor is one of the part of it.
Yeah, that's true. But does this
Yes.
give confidence to the foreign direct investors?
Hope so.
Hope
I
so.
hope so. I can't say yes no. Right.
Bagga sir, your view, does this promote FDI broadly?
I think if you go by the looks of it, it is certainly softer than the earlier regime because it is more clearer. But if you ask me, I don't think it takes away the core issue which the foreign investors had, and that was the absence of an exit policy for employers. That remains. And the threshold being increased from 100 to 300, that's in another code, is hardly of any avail. But yes, there has been certain easing of restrictions and unification of compliances, which are certainly far, it provides a far better and more attractive regime than what we had earlier.
Yeah, it is a step forward, I would say. Not great step, but it's a step forward. Yeah, sir, there's a question from Mr. Pradeep Patil. Is it mandatory to issue appointment letter to contractuals or only for your employees?
Contractor has to issue the appointment letter.
So everybody would eventually get covered.
Yeah.
Now the contractor, now one further thing I'll add. Contractor will issue the experience certificate to the contract employees
Yeah, sure.
in the prescribed format.
The prescribed format is there.
So once you have one experience certificate can be issued only if the appointment letter is there.
That's true.
Yeah.
Question from Mr. Sujay Purohit. In case the employer forces a woman employee to opt for the night shift or else leave the job, what rights will the woman employee have?
I think the provision clearly states it is with the consent of the employee, so there is no problem there.
Yeah. Form 8 of which rules referred to with respect to duties of employees? I think it's a Form 8 of the central rules, draft rules that have come up. I just tried to kind of club that together. Mr. Nandeshwar is saying the annual health checkup of employees is a positive step. However, will it not lead to fire? I think we answered that. I'm sorry.
Yes.
I'm repeating that. How the license at all India level will work. Example again, Team Lease provides manpower of all India. How it will be implemented?
So the form that is provided for All India license will take into account trans border issues of states, etc. So you will have to wait for that form to come.
Sure. There is Manas Singh, who will be inspecting authority in case team leads provide manpower at all India level and establishment having registered and under Shop Act, which is under state law. I think team leads has a lot of questions, I believe.
No, so I think team leads needs to read these definitions of the employer and who appropriate government, and then decide who their appropriate government will be.
Yeah, Mr. Sumit Paul is asking a question. Is there a wage limit to define a workman?
There is no wage limit for the defining workman. For which work, under which act? Because Sales Promotion Act defines 18,000.
Correct.
Interstate migrant workers are defines for 18,000, irrespective of whether it's supervisor or no. Their question is not there. But for the other things, under factories, for building constructions, it defines supervisor drawing more than 80,000 rupees. They are excluded. All workers are included.
Okay, there's a question from Rakesh Shah. What is the product liability regime? I'll try to answer that. You see, what has happened under this code is that they have said a person who kind of manufactures, design engineers, manufactures and sells any machinery or equipment, including, let's take an example of a lathe machine, that it has to be completely safe for the purpose for which it is being used at the workplace, and therefore the liability would get fastened onto the manufacturer. This has been a huge issue on the nuclear liability from the reactor's perspective as well. So I think that's broadly the product liability regime. I think there are some questions on the chat. I'll kind of quickly move ahead. Uh, Dilshad Shaw says, very well said, Mr. Bagga. I think that's a great comment. Would you be able to share website link of rules to keep referring to? Yes, I'm requesting Risha, Mehak, and Jyoti to share those links. Annual health checkup was always mandatory. This is, in fact, made it beyond 45. I think we answered that. We've looked at the changes in law seem to address more on organized sector. What about unorganized sector? I think we touched base on this. Mr. Kulkarni is also saying that, what happens to those sugarcane farm workers who are being highly exploited today? Will contract labor regime end? Is another question from Anshu Mukherjee.
The sugarcane, if they are working in the sugar mill, they will be governed by the code. But if they are not working in the mill, the code doesn't apply to people outside the mill.
Yeah. One second. From Indrayani Aglave, I think please share notification for overtime 125 hours quarterly limit. Existing limit is 115. I think it's part of the draft rules. We will share the link to the draft rules. Kindly throw light on applicability of standing orders to a corporate office or any commercial establishment.
That will be in the next webinar. We will be taking that.
Is this labor code applicable to sales employees?
Yes.
Yes.
Yes. Whether boiler operations would fall under the core activity?
May not. That you have to figure out what is your industry. So that leeway is there with you.
Okay. In appointment letter on point number 11, avenue for achieving higher wages and higher position, whether this be an objective statement or it is simply yes or no.
It's not objective.
It is not objective. Okay, fine. Dilshad, thank you very much for your compliments. You said this is an excellent session. I'm just going to request Risha, are you able to put up that slide?
Is it visible?
Not yet.
Not yet.
Okay, 1 second. There's some technical glitch here.
Yes. It's an expression of gratitude. Thank you to everybody. Thanks a lot to Mr. Bagga and Mr. Pagar. Today is an Advocates Day, so we kind of are commemorating this on Advocates Day. It just happened incidentally. But thank you very much, Jaideep Kevalramani, CEO of Legacy Services. Thanks a lot to Jyoti who's kind of heading delivery and of the compliance solution. Thanks, Mahek, for all your efforts. Thank you very much, Palak. Thanks a lot, Avni. Thank you, Manisha, Risha, Ayush, and Mahi for all your help, research, and support to us. Uh, Thank you very much to the entire audience. Uh, I think we look forward to the fourth session very soon. And there have been a couple of requests that have come up to say that we need to actually summarize everything together in one session and look at how everything meshes together. But we'll come back to you with that plan. Thank you very much to everybody. Thanks a lot. Have a great evening and kind of safe working places very soon.
Okay. Bye. See you.
Thank you, sir. Thank you.
Thank you.
Bagar Saab, thanks a lot, Bagar.
Thank you. Thank you. Thank you.